Thank you everyone for coming out today. I'm Joel Hyatt and I'm joined by Kara Murphy. We're the co-chairs of the Lee County Bar Association General Civil and Business Litigation Practice Area, and we've got a great CLE for you today. Today's CLE is on voluntary trial resolution and using a private judge under Section 44104 of the Florida statutes. And we're so excited because given a lot of the changes to the case management deadlines that have been set forth by the Florida Supreme Court, we really feel like this might be the next big thing in litigation. We've got a great panel for you today. We're joined by the Honorable Christi Underwood and by Mike Whitt. Judge Underwood served as a judge for the Circuit Court of the Ninth Judicial Circuit. Prior to her judicial service, she was in private practice, serving as an arbitrator, primarily in construction-related matters. Since retiring in 2018, Judge Underwood rejoined the National Panel of Commercial and Construction Arbitrators for the American Arbitration Association and the International Center for Dispute Resolution. And Judge Underwood also currently serves as a private judge in construction-related matters. Mike Whitt is my partner here at Hahn Lozier and Parks. Mr. Whitt is board certified by the Florida Bar as a specialist in business litigation. He has over 35 years of experience as a trial lawyer. He focuses practices on the areas of eminent domain, inverse condemnation, and business and real estate disputes. Mr. Whitt has experience using a private judge, and that's one of the reasons we've asked him to join us today.
So Joel and I called this Concierge Court, and we're really excited for you all to hear what we have to say about it, because I think it's from the people on the screen. I know there are going to be people who are going to spread the word and get this information out to other members of the bar, since it's something buried within the statute that isn't often used. So with that said, Judge Underwood, would you mind giving us a brief introduction as to what is voluntary trial resolution?
I would be happy to. Obviously, you can read the statute and get a sense of what it's all about, but just to sort of cut right to the chase, a voluntary trial judge is a person who has been selected by the parties to preside over the trial of their matter that is pending in the circuit, typically in the circuit court. The person that they select must be a Florida bar licensed attorney in good standing with the Florida bar for more than 5 years, or that person can be a retired judge. I have served in this role in a case this year that lasted quite a long time, about 6 weeks. And pursuant to that statute, I'm serving as the bench trial, not presiding over a jury, but serving as a bench trial judge. And as part of that role, the private trial resolution judge presides over all the hearings leading up to the trial. You rule over motions throughout the trial. It's the same as if you're in the courtroom. You know, you're swearing in witnesses, or you have a court reporter who is doing that along with you. The parties have to coordinate exhibits through the clerk's office. There are some jurisdictions in Florida that allow you to hold the trial in the courtrooms, in the circuit courts. It's my understanding that most do not. I don't think it's reasonable to have that expectation. But the statute, I don't know when it was enacted exactly. Someone else who's presenting today may be able to answer that question, but it clearly provides options to the parties that they normally in the past have not had the option to choose an outside judicial person or a lawyer who satisfies the criteria to preside over a bench trial.
Thank you, Judge. We're going to talk about some of that meat in a little bit more detail. Joel, you want to ask the initial question of Mr. Whitt?
Sure. So Mr. Whitt, let's say somebody is interested in taking their existing lawsuit and removing it to voluntary trial resolution. From a practitioner standpoint, how do they do that?
Well, both parties have to agree in order to take advantage of the voluntary trial resolution legislation that's there. Both parties have to agree to it. It's fairly straightforward. The parties would file an agreed motion under 44.104 to have a voluntary trial resolution judge appointed. Now, it's important to say you don't have to just do this in an existing lawsuit. You can agree to do this and have a voluntary trial resolution judge handle the case from the very outset. And if you do that, the parties agree, they have to agree in writing. You file the suit and you pay all the filing fees. And then you would submit that to the court. A court order is required to appoint the voluntary trial resolution judge. So that's the nuts and bolts of kind of how you go about doing it. You can, agree before the lawsuit. The case that I have, where we have a voluntary trial resolution judge, the action had been pending for a number of years. It's a pretty complicated construction case, and we anticipate somewhere around a 3-week plus trial. And that's what prompted the parties to say, given the current state of the caseload of circuit court judges in the 20th Judicial Circuit, we didn't think that there was any prayer that we would get a 3-week trial start to finish. We knew that we would be broken up into days at a time, maybe if we're lucky, a week here and a week there. We have a lot of out-of-state experts, so that was just going to present too many hurdles to try to overcome. So the parties all agreed to hire a voluntary trial resolution judge, submitted the order, had the order entered.
Kind of a follow-up to that, Mr. Whitt. You had mentioned that the parties basically file their agreement with the court. Does the trial court have any sort of discretion in whether or not to approve the use of a private judge?
That's a good question, and the answer is no. In fact, there was a case that came out of Miami and the third district, I want to say 2 or 3 years ago, where they submitted this agreement and the agreed motion to appoint a voluntary trial resolution judge. And the circuit court judge says, nah, I'm in control of this case. I really think it's in the party's best interest to continue to have the court handle this dispute. The parties took it up on appeal, and the trial judge got reversed. And they said, if the parties agree under the statute, you have no discretion to deny the motion. You have to appoint the voluntary trial resolution judge.
And that case that Mr. Whitt was just citing to, that was part of the materials that we sent to the section this morning. So if after this you say I have a good case for voluntary trial resolution, feel free to include that case law in your motion, that the court has no discretion so long as the parties all agree.
So Judge Underwood mentioned this earlier in her introduction, and we have Judge Hayes also on this Zoom. The private judge does not actually have to be a former member of the judiciary. The statute says that it can be any member of the Florida Bar in good standing for more than 5 years can act as a trial resolution judge. From your perspective, Judge Underwood, what factors should you consider, or what characteristics should you consider in appointing a private judge?
Well, I think these factors go to whether the person is a retired judge or a practicing lawyer in the state of Florida. First, look at what is your dispute about. You need to retain, if you have this option, the parties can agree upon who they are hiring to serve in this capacity, in this role. They certainly would want to choose someone who had some knowledge and some expertise in the background of the dispute. Especially if it can be sort of balanced, so they haven't represented one side of that particular subject matter their entire professional career. So if there has been some balance in that area of expertise, that would be an ideal candidate, whether they're a retired judge or a practicing lawyer. And then the next issue that I think is very important, regardless of where they come from and their background, if they meet that first hurdle, have they had trial experience? Are they familiar with the rules of evidence? Are they familiar with courtroom procedures? Have they ever had bench trials where they were either lead counsel or second chair on more than one occasion, so they have some familiarity with the process? The other issue might be if it's a case with a large number of exhibits, whether or not they're comfortable with handling a large number of exhibits, keeping that organized with someone in their office, and also anticipating issues that might come up on appeal during the process of the trial itself, because that is very, very important. It needs to be documented properly to protect their client. So those are just things that come to mind.
And to follow up on that, we're going to touch back on the statute and the appellate rights that are governed by it. But other than some of the things that we talked about with the courtroom not being able to be utilized per se, and you may have to have a private venue, can you tell us from a sitting judge's perspective over these, can you tell us exactly what some of the differences are that we would expect?
Yes, and that's a very good point, and I mentioned it when we spoke on the phone a few weeks ago. Some participants in this new process have the concept that they think that they're going to be able to try their case in the courthouse and use the courtroom in the courthouse. And that's wonderful if they have an arrangement or can work out an arrangement to do that. But I think it's really should not be expected. I think it's the exception rather than the norm. For one thing, courts are just, slammed with their own schedules. They're all trying to coordinate their own trials. Sometimes they're sharing courtrooms. So for you or the parties who are choosing this option to come in and introduce now another new judge who's going to preside over a trial, I think the parties need to realize that it's best in their client's best interest to make arrangements for either a conference room, rent a conference room, perhaps rent a hotel that would allow their witnesses to stay if they're traveling from out of town, and have a conference room that is set up for the duration of the trial. Alternatively, if one of the lawyers has a large enough office that they could accommodate lawyers from both sides, witnesses from both sides, a court reporter, paralegals, and the sitting voluntary trial judge for a duration of time, they could do that. But that is certainly something that needs to be taken into consideration. The other has to do with the proximity of the location of the trial to the lawyer's offices, to the witnesses who may be coming and going throughout the course of the trial. I just sat in one of these types of cases this year. It's not finished yet, but it lasted for 6 weeks. It was not where I live, so I lived in a little hotel suite that was a part of the hotel where the conference room was rented for me to stay throughout the duration of the trial. That worked out perfectly, but keep in mind also, whatever space is rented must be compliant with the ADA laws. This space must be open to the public. So you cannot just hide away in some hotel and close the door. You can close the door, but if in the event someone knocked on the door and wanted to sit in and observe, and they're a member of the public, then that is their right. So they're just little nuances you have to be aware of. Some of it's just common sense.
Once the trial is underway, though, we're talking a normal trial under normal rules of evidence, under normal rules of civil procedure. I think everybody on this screen is very familiar with the non-binding arbitration process under Florida Statute 44. It is not that, in that it is not proffers, it is not a loose standard of evidence, it is a full trial. Is that correct, Judge?
It is absolutely correct. A court reporter will be sitting in the trial just like they are in the courtroom. You're swearing in witnesses. If there's an objection to be made, it must be made on the record. The court makes a ruling on the record. If it's something that they need to hear additional research or additional argument, The flexibility of this process is wonderful. You know, you can take a 15, 30-minute break. You can take lunch early, give everyone an opportunity to prepare to make arguments on issues that come up throughout the trial. You're having to maintain the order of exhibits. You have to work, whoever's participating in this, the law firms, you have got to also coordinate with the clerk's office to make sure that the manner in which you are handling exhibits throughout the trial coincide with the clerk's wishes, because there are protocols for evidence, and that must be met, that must be satisfied. But it's just like putting on a regular trial in a courtroom. So you have proffers. Sometimes the proffers would be outside of my hearing. I would step out of the room and let them put a proffer in support of a position the parties might take that I have overruled or granted an objection. So everything that you know about trials, it happens in this alternative environment, the same as if you're in a courtroom. You just don't have the deputies coming in and out. You don't have, you know, all of the advantages that you have at the clerk's office, rolling the exhibits in a, you know, sometimes in a little shopping cart in and out. But all of those things have to be complied with. It has to be meet the protocols of the circuit where your cases preside is pending, and it can be done. It's easily done and accomplished, but you just have to give thought. So the person you select to do this, really, it's best for the parties if you're choosing a lawyer that they have prior trial experience, so they know how this works. What do you put in a pretrial order? You know, how do you handle proffers? How does the court rule on pre-hearing motions? You've got depositions that are filed. You have evidentiary objections. You have witnesses coming in and out. There are a host of things that can happen during trials. And so you don't want to find someone to serve in this role just because they happen to be a nice, you know, wonderful 5-year plus lawyer, but they've never been involved in litigation, because it could be very costly for the parties, since you've gone to so much trouble, the parties have, to set this process up.
Yes.
And we've kind of jumped to the end a little bit. And Mike, I'm going to ask you from a practitioner's perspective in just a minute, but to be clear for everybody that's listening, the trial resolution judge oversees all of the pretrial matters as well. It's from discovery motions, it's motions in limine, we have Daubert challenges, whatever the circumstances are, from the period of time in which we've elected and the parties get that order entered. That is now the trial resolution judge. So I just want to make sure that everybody listening is very clear that this is not similar to a senior judge stepping in just solely for the trial, where your traditional circuit court judge has made all of the pretrial rulings and had all of the preliminary hearings. This is your opting out of circuit court, and you're having your now trial resolution judge handling all of the matter as if it was your traditional circuit court judge. Correct, Judge?
Yes, that's
Great.
exactly right.
Great. So Mike, from a practitioner's perspective, can you fill us in on anything that you see from the mechanisms from a regular traditional circuit court trial versus this trial resolution process, other than venue? Because I think we've kind of talked about that quite a bit.
And when you say venue, Ms. Murphy, you're talking about like where the trial will actually take place, physically,
right? Like whether the
physical
court,
plant?
whether it's the courtroom or whether it's I mean, it sounds like more likely than not, just the local process is not going to lend itself to us trying a case maybe on the 5th floor of Fort Myers or downtown in the Collier. It's probably going to have to be a hotel suite or something to that effect. So,
Well, I started to say I may have a differing view of that from Judge Underwood, and there's a couple of reasons why. My reading of the statute, it's not clear on the face of the statute that this is limited to a quote unquote bench trial, that the voluntary trial resolution judge has to be the one to make the factual determinations and ultimately kind of return the verdict or return the decision. The voluntary trial resolution judge may do that by statute, but I believe this may be open. It says any civil dispute that may include a jury trial. You could potentially have a voluntary trial resolution judge presiding over a jury trial. If that is the circumstance, doing that in a conference room or something in somebody's office, that's a problem. I would note that we have the enabling legislation in Chapter 44, but there are no rules of procedure. The Florida Supreme Court has not stepped into this space. The Florida Supreme Court has adopted no rules of procedure dealing with this, which I believe may be something to come in the not too distant future. 44.104 subparagraph 5 that deals with the clerk says the clerk of the court shall handle and account for these matters in all respects as if they were civil actions. That raises issues to me really about the strict controls over evidence that's offered, evidence that's admitted. And there are a number of circuits around the state that have adopted local rules and administrative orders that require that the matters be tried in the courthouse. The bailiffs, court administration, the clerks, just as if it were a regular civil case going before a circuit or county judge in those circuits. The 20th does not have such a rule. However, the Honorable Hugh Hayes adopted his own standard kind of back in the day, and that's where Judge Hayes came down and said the clerk's going to be involved, court administration, bailiffs, etc. If that's where you decide you want to try the case, the parties always have the right to agree to try it offsite. And that may be the best circumstance. And Judge Underwood, that's kind of one of the pros and cons that she raised. So, you know, that's my take on some of these factors. It provides a lot more of kind of a wide open landscape on what the parties may agree to. And Carrie, your point of the trial resolution judge handling everything, that's exactly what we have right now in the case that I have that's pending. It's wonderful because you don't have to wait 3 or 4 months to get, you know, a 30-minute hearing time on a discovery motion or other motion in the case. That can be resolved very quickly, which means the matter is proceeding very quickly. Like the magistrate system is a bit flawed in my estimation, because while the magistrates do a great job, the other party can file an objection to that, and then you have to go right back on the docket waiting to get circuit court hearing time in front of that judge, which could take 3 or 4 months to get time. So you know, you have the time and expense to go through magistrates, and now you're going right back with the same issue in front of the judge. So not so with a voluntary trial resolution judge. It's done. Those motions are being addressed. And I'll jump on the comment that Judge Underwood made about it doesn't have to be a retired judge. It's you know, a Florida attorney, 5 years or more of experience. I personally would not look at using any attorney to act as a voluntary trial resolution judge that was not either a board certified business litigation lawyer or a board certified civil trial lawyer, because the Florida rules of evidence apply, and you have to have someone who knows the evidence code like the back of their hand, just period, or you're going to have big problems.
To kind of piggyback on that a little bit, Mr. Whitt, there might be some people who are still saying, oh, well, this sounds an awful lot like binding arbitration. Could you please help us all out? How is this different from binding arbitration?
Well, binding arbitration, the rules of procedure are not strictly applied. That's one of the big things. And there's very limited discovery, if any discovery, in arbitration. You have either a single arbitrator or an arbitration panel. Like I mentioned before, there's no exception or preclusion of having a jury in a voluntary trial resolution scenario. And the whole, and I've arbitrated a number of cases through JAMS, through AAA, and under the Florida Arbitration Code. where the parties agree to an arbitrator. And the limitation on appellate rights, that's a huge aspect of the difference between voluntary trial resolution and arbitration, because in arbitration, you largely have no appellate rights out of 99 point something % of arbitration awards. And not so with voluntary trial resolution. So this is truly, I think it's the way of the future for civil disputes, because the courts are so overwhelmed with cases. The legislature only provides so much by way of budgeted dollars to go to the judiciary to hire new judges, etc. And Judge Hayes may be able to speak. I don't know if he has his finger on the pulse of the current caseload with the circuit court, but one of the judges here in Lee County, I was in front of him about 2 weeks ago. He said they used to average around 2,000 cases on their dockets, and now they're well over 3,000 cases on their dockets, probably approaching about 3,500. That's just untenable. So, and you have all the new Supreme Court mandates saying, push the case, push the case, push the case. You've got all these deadlines. So yeah, I'm not the big fan of arbitration for the reasons that I mentioned before. I don't like kind of that loosey-goosey approach with no rules of evidence that's there and the lack of appellate rights. But I've been a big fan of voluntary trial resolution thus far.
So in terms of just the nuts and bolts for everyone in attendance, if you look at 44-104, it strictly provides that you get a final judgment. So the voluntary trial resolution judge enters a final judgment, and then it says that any party may enforce the final decision by filing a petition for the final judgment in the circuit court. And then, as Mr. Whitt was alluding to, you have full appellate rights. The only caveat is the factual findings determined in the voluntary trial are not subject to appeal. The conclusions of law and how the law applies to those findings of fact, those are subject to appeal. But that's huge when you compare it to binding arbitration. And
Judge Underwood may be able to speak to this, but I'll just pepper that soup pot a little bit, Mr. Hyatt, with what appeal do you have an appellate court review the factual findings anyway? I mean, it's pretty rare. They're looking at errors of law. You're not going to have many where you've got some kind of a de novo review, and the appellate court's going to substitute its judgment over the fact finders. That's just really not going to happen. So, to me, it's almost no loss of what is a typical appellate right coming out of a voluntary trial resolution, that voluntary final judgment. So yeah, and it's just that step that you have to take. It has to be a court that enters the final judgment for it to be effective. I mean, that's based on the statutes in Florida. So, that's it. You've got it. You present it. The judge is going to enter the final judgment, and then you're off to the races, going to appeal or not.
And let me just toss something else here into the fray. Mr. Whitt, I agree with you on those comments. I just want to also bring out that there are optional appellate procedures under both the American Arbitration Association rules and the JAMS rules. They're not frequently utilized, but they do nonetheless exist, and both organizations have impaneled arbitrators on those arbitration appeal panels, and they have had cases go all the way up and even reverse before. So it's not widely known, but they are out there. So I just thought I'd throw that out for the information.
Yeah, that's a good point. It's a very good point.
I'm going to deviate from the outline for just 1 second, and it's
No,
really just because something In part because I think it comes down to, just from the practitioner's perspective, understanding some of the nuances. So for example, let's say in your case, you had an open case and then you opted for the trial resolution process. So there was already a circuit court case open, which you could then apply back to that same circuit court judge to have your final judgment enforced. That's easy, similar to compelling binding arbitration and then going back and having them confirm the award and ultimately exercise it. Where do you file your pleadings? Are you still filing it in the circuit court, which triggers the clerk of courts to still monitor your pleadings? So that's the first question I have for you, Mr. Whitt. And the second question I have for you is when is the final judgment rendered for appellate purposes under the appellate rule? Is it when the trial resolution judge enters the final judgment, or is it when the circuit court judge enters the final judgment? I'm not certain that, since there's no case law on this issue, that we're going to get necessarily a definitive answer one way or the other.
Well, starting with the last question first, the statute says that the voluntary trial resolution judge will render a final decision. And then that decision is taken to the circuit court, who enters the final judgment. So I believe the rendition of the final judgment and when the appellate clock would start ticking would be upon the entry of the final judgment and the docketing of that final judgment by the clerk. I believe, and that's a good question. It's a little gray, Ms. Murphy, under the statute, but I believe if you were to take this to the circuit court from the inception, the parties agree, you file, the statute is clear, you file the petition, if you will, in the circuit court, you file it with the court. The case is opened up by the clerk. You have to pay all the filing fees. And I believe at that time that there's a judge appointed to that case, because to get the voluntary trial resolution judge appointed, it takes an order to appoint that judge. So I think that is going to be how it happens. You pay the filing fees, everybody's agreed up front. There's a judge that's assigned, it gets sent over to the judge enters the order appointing the voluntary trial resolution judge. That's my understanding of how from the inception you would get the case filed and get the judge appointed. I see Judge Hayes raising his hand. And I'm not a moderator. Maybe you guys want to acknowledge him or
No,
not.
it's great. We're very lucky we have Judge Hugh Hayes here. I think everybody on this Zoom probably knows Judge Hayes and has had cases in front of him. He's a long time on the circuit bench down in Collier County in Naples.
Longest.
Yes.
No, thank you very much. One thing I would say that when I was serving, because I've almost been out 2 years now, but because these cases could come directly out of a direct file into the clerk of courts, the feeling, and it changes, of course, but the feeling used to be from the trial judge that was assigned to the case, if you're willing to try my case and take over my case, I'm willing to find you a courtroom. And so they were generally very favorably inclined to help you in any way they could, because you're reducing their caseload. The thing that's kind of odd about it, that I would tell you that, I was going to ask Judge Underwood as well here the question, because a long time ago, when I was the chief judge for the 20th Circuit, and I used to sit up at the 2nd District when we were in the 2nd, at the 2nd District Court of Appeal, and I can tell you kind of a funny story that now that I'm no longer a judge and Chris Altenburn is no longer on the 2nd District Court of Appeal, he can say whatever he likes, but he was a very outstanding jurist. He's always been, I used to jokingly tell the lawyers when I was on the bench, if you want me to DQ, just go hire Chris as one of your associate lawyers and I'm gone. Because I just had that friendship with him that anyway. The thing that was one conversation we had one time about the trial resolution judge was, where does the appeal go? And we did not know the answer, but I can say at the time, which was a few years back, Chris's theory was that it went directly to DCA. And so and one of the reasons I think we discussed that was if you got it and it was already assigned to a circuit court judge, and then the trial resolution judge entered a ruling, how can you appeal that to the, in essence, circuit court judge who might have actually had the case, or, did they give it all up to you? And it's not clear. It was not clear to me at the time, and I do not know the answer now. But Chris and I had decided at the time, it sounded like that the trial resolution judge, once that ruling was going on appeal, take it directly to DCA. Now, the other thing is that only circuit court judges, or only judges, I'll say this, I'm trying to figure out how to keep everybody out of trouble. But when cases go up to the appellate court, there is the presumption of correctness. However, it's not unwieldy for them to go back sometimes and re-examine the facts, and from their own point of view. And I think they are legally able to do that. So there is this presumption of correctness when it comes up. And again, I'll attribute that to Judge Altenburn. He used to say that they put a heavy reliance on a trial judge's rulings and to try to give them a presumption of correctness. It came to the appellate court on that basis. So I'm not really sure. The other thing I would say with with Mr. Whitt is that the only experience we ever had with the issue of the trial resolution judge was plaintiff's bar was generally always in favor of it. Defense bar often said, I have to talk to my client, and my client is concerned about this, and it may be very well an insurance company. And then they say, well, we'll think about it, we'll think about it, we'll think about it. And it may be 3 years before they ever give you an answer. And so the experience that we had at the time was plaintiff's bar was in favor of trial resolution judge. Defense bar was always like kind of dragging their heels on it. But anyway, I'm out. Go ahead.
Thank you, Judge. All right.
I think it's a great plan though. And I don't know whether Christi, I've sat in on one of her presentations before, and she is truly outstanding. And I don't even know she ever knew Bob Beach over in Pinellas County, but a lot of this statute that we have on the trial resolution judge came from a guy who's, I hope is still with us, but who was originally from California and said, I want Florida to pass the California Rent-A-Judge program statute.
Concierge, that's what we
I
called
have
it
always-
instead.
I have always called this statute the Bob Beach statute, even though he may have had nothing to do with it. He was a very fun guy to know.
Too funny.
Great.
So kind of circling back around, Judge Underwood, what are some of the pros and cons of utilizing a private judge and voluntary trial resolution in your experience?
The most obvious pro is the parties get to choose their judge. So that's pretty important.
It's a big one.
If they trust the person they're choosing, whether it's a lawyer or a retired judge, that's a really nice option that they're given under the statute. Another pro is that they can have a time certain trial date. So as Mr. Whitt mentioned a few minutes ago, parties who have these cases, and Mr. Hyatt, I think you did too, when you have a case that's been pending for years and years and years, and it might be a 4-week, 5-week, 6-week case, it's very difficult to obtain a spot on the trial docket. And then if you do, you're oftentimes subject to cases before your case. So it's not really a time certain case unless in my circuit, sometimes we had the privilege of having a trial. One of our colleagues would just serve in the role occasionally as the trial judge. And so, for example, I had 6 weeks 1 year of this trial judge's time. So I saved my bigger cases for my 6 weeks with the rotating colleague who was the trial judge. But absent circumstances like that, unless you can obtain funding to bring in a senior judge to preside over a lengthy case, it's very, very difficult. And as you know, my background as prior to law school and then practicing as a lawyer was in the commercial construction area where you have multi-million-dollar projects that go on for years. And then when they're involved in litigation, they go on for years. So it's very difficult to secure time certain trial time for a case like that might take 5-6 weeks long. And just the cost of the money alone probably pays for the trial judge process, the voluntary trial judge process, because the interest on millions of dollars every day, and then you gear up for a trial and there's so much time of lawyers have to spend to gear up, and you're ready to go, and you're like 4th or 5th on the docket and your case never makes it. So you're back on the docket again 2 or 3 months later. It's very costly. So the advantage is you get a time certain trial date, and you can have faster hearing times. And I think you all mentioned that a little earlier about your experience now, Mr. Whitt. It's much easier to get a fast hearing time. You can accommodate witness schedules easily. So I gave an example of this 6-week case I've been serving on. We're not finished with it quite yet. We thought we were. But, we would find out, okay, this witness has to fly in from an out-of-state location. So we rearranged the schedule for this particular witness when they come in, and lo and behold, they couldn't come in, or the plane was late, or they had some kind of difficulty. So it's very easy just to rotate around. A couple of times we just ended early. Everyone went home. We reconvened the following Monday. So it has a great deal of flexibility. So those are all pros. The cons: it costs more than having the regular presiding judge in the circuit court presiding over your case, because you're paying for this private trial judge. And it's typically lawyers' fees, about the same rate that you'd be paying for a lawyer in a similar like kind case. You also have to, if you cannot hold the trial at the courthouse, which I'm happy to hear some jurisdictions accommodate that, but if you're not lucky enough to have that type of setting, then you're going to have to pay to either rent a conference room somewhere, or you otherwise make arrangements through lawyers' offices if they're large, if their conference spaces are large enough. But I don't think you can go into this procedure expecting that you're going to have a courtroom in the courthouse just because of the competing interests of all the other litigants in the courthouse system. And then you've got to accommodate the clerk's office. So if you hold the trial in the same city where the case is pending, I haven't done this, but you might consider asking if you could have the clerk in the clerk's office, have them assign a clerk to come to where your trial is held each day if it's off-site. That might be an option that would make the clerk happy. In my particular case, the paralegals in my case met with the clerk's office. I sent them first to the judge's JA. I said, coordinate with the judge's JA, who they would like for you to work with in the clerk's office. Go talk to the clerk's office, see if you can come to an agreement on protocols for the evidence and how you maintain it. And they were able to do that in a satisfactory manner. My particular case, it's pending down in Miami-Dade. The flexibility this process provides, we held the trial up in Fort Lauderdale. It was closer to the lawyers' offices. I took the Bright Line train down once a week, for Sunday for a starting trial on Monday, took the train home Friday night. I'd come back on Sunday afternoon, worked out beautifully. So there's a lot of flexibility. If the case is large enough, if there's enough money at stake, the interest is so high, and you really want a time certain trial, I think the positives outweigh the negatives.
And Mr. Whitt, from a practitioner perspective, any additional pros or cons of the voluntary trial resolution process?
I think the judge hit pretty much all of the pros and cons that I had in mind. Just a couple of things. Dealing with the cost, yes, you're paying the voluntary trial judge, you're paying for the time. You may have to pay to rent a certain location, for whatever site you're going to have the trial. But I believe overall that you're going to enjoy a cost savings. She mentioned the interest. That's kind of what we have in the case that's pending now that we're using, millions of dollars at stake. If you just think of the per diem interest, and if we can get that case resolved months and months and months quicker than if we had to go through the trial through the circuit court, you're actually going to save money there. All of us know, every practitioner, if you do trial work that's dialed into the Zoom, the longer a case hangs out, the more expensive it is. And we all have had situations where you're set for trial, you're ready to go to trial, you gear up, you do all your final prep, witnesses are booking flights and all of that, and then bang, something comes up. There's some medical emergency of one of the parties or one of the attorneys or whatever, and then you get rolled. And it's not like you're going to get rolled a couple of weeks. You may get rolled 3 or 4 months down the road. Guess what you have to do? You have to gear up everything again, all the machinery, go back and review all the notes, all the stuff. So yeah, it's like preparing twice for trial. I mean, I've had that happen any number of times in 30, however many years I've been doing this. So, and then one little tidbit that I wanted to throw in, we didn't talk about, just talking about the site of the meeting or the hearing. If it's in the courthouse, what do you have? You have courtroom security. You're going through the metal detectors. You've got security. You've got bailiffs standing there with guns on their hips. Most of the time, and this is true in the case that we've got going now, the parties are all business people, and the lawyers get along very, very well. And that's the reason we were able to reach the agreement. But let's think about the case that while they may agree it makes sense and you get a voluntary trial resolution judge, the parties really don't get along that well. There's a lot of acrimony there. That security component is something to be taken into consideration. And I think that can be just part of the expense. I think the parties could say, hey, we're going to have an off-duty Collier County Sheriff or Orange County Sheriff, or wherever the case is. We're going to hire somebody that's got the 9mm on their hip to be standing there and to make sure that we don't have any problems during the pendency of this voluntary trial.
That's
an excellent point.
So we're starting to run short on time. We definitely want to be able to open it up to see if there's any questions. Hearing none.
Everything you wanted to know about voluntary trial resolution and don't even have any questions. That's fantastic. Judge, you did a good job.
Thank you all. Thank you, Judge Hayes, as well. I appreciated your comments in particular.
Judge Underwood, if anybody wanted to use you in one of their construction-related matters as a private judge, where can they find you?
Probably the best thing to do is to email me. My email address it's my initials, CLU@CLU, then a hyphen, law.com.
Wonderful. All right. Well, thank you, everyone. I hope that everybody found this as interesting as we do, and I really believe that this is the next big thing. I think that once people realize that this statute exists and that there is another way besides binding arbitration, and going through with the current case management orders in place, that there is a third door that you can take, and we found it to be a very good experience all around.
And I would also just like to say thank you to Mr. Hyatt, Ms. Murphy, and Mr. Whitt, and for the Lee County Bar Association putting this program together. I think this subject matter is not as well known as it should be, and the courts in particular, the judges that I've spoken with, my colleagues I used to work with, are very happy that the concept is starting to pick up speed a little bit, because I know my last division was in the civil division, and we were just overwhelmed with cases. So many cases that, you know, you could work 7 days a week, and I oftentimes did, and you just can't keep up with it. So this is a nice option for those with the very large complex cases that are lengthy, and also just a great option for any parties who might be otherwise interested in having their case heard a little sooner.
Excellent. Thank you all very much. Appreciate the opportunity.
Yeah, thank you both very much for your time.
Thank you.
Bye, everyone.